Okay, hello. It's Monday, March 21st, 2016. Happy first day of spring. And this is the first of two taped lectures on the Commerce Clause materials. I'm not going to produce a videotape for what we did in class on February 25th. We covered very well the period from the founding to the New Deal. We did cover the New Deal and the subsequent Commerce Clause cases, but I want to review that here. And then in a second video, we'll go into somewhat more detail about the modern era, the Lopez case in 1994, which was the first time the court invalidated a congressional statute under the Commerce Clause since 1937, and Morrison and Reich and the Affordable Care Act case. So let's get started. I want to begin with the New Deal transformation. I'm using the PowerPoint labeled PowerPoint number 2. I sent it to you. It's on the NYU classes, and there's about 20 slides in this one. So I'll refer to the slides as we go through. To begin, as most of you know, the New Deal is a great turning point in American political history. It's brought on by the Great Crash of 1929 and the Great Depression, and this is a transformation that involves a partisan realignment, vast reinterpretations of the role of government and the role of the national government, transformation of constitutional meaning, and so on. And we begin with a couple of puzzles, right? The main puzzle for our purposes is this: between 1932 and 1938, the meaning of the Constitution changed dramatically. Or at least the Supreme Court's understanding of what the Constitution meant, what it allowed the national government to do with respect to economic and social regulation, changed dramatically. Yet the words of the text did not change at all. Nobody went through a process of amendment, and that's spelled out in Article 5 of the Constitution. It's an arduous process. Change didn't happen through Article 5, yet change occurred. So what does this episode tell us about the sources of constitutional change, sources of constitutional meaning? How should we understand this period? How did the winners, the New Dealers themselves, understand it? What story did they tell about it? Is that an accurate story? It's a controversial one. We'll get to that in a minute. So I want to review some of the developments, and we are here focused on particularly the Commerce Clause cases. We're going to tell this story again later in the semester when we get to substantive due process and the Lochner case, which most of you had not heard of. Certainly you've heard of Roe v. Wade. What's the connection between Lochner and Roe, and how does the New Deal transformation figure into that? So we're going to return to this story. This is a crisis that comes on suddenly. We don't have any kind of long simmering dispute as in the run-up to the Civil War. We just have an economic catastrophe. The economy tanks in a huge way, and it's a severe and long-lasting depression. Suddenly, 13 million people are out of work. That's a 25% unemployment rate. State and local sources of charity dry up. We have homelessness in tent cities springing up around the country. By 1932, less than 3 years later, industrial production had been cut in half. 5,000 banks failed. 9 million individual personal savings accounts were wiped out. There's no Federal Deposit Insurance Corporation back then, no FDIC to guarantee or insure your deposits. So it's a huge crisis. It was Herbert Hoover's great misfortune to be in office when this happened. And he did take certain actions, right? But what he did was limited by historical experience. There had been depressions before. The last big one was 1893, and these were regarded as necessary corrections that would last a few years, and then things would get better. So there wasn't any historical experience with the depth and global nature of this crisis. And he was also limited by his understanding of what the Constitution allowed him to do as president and what it allowed the national government to do in response. I mean, it was a constitutional understanding. So when things aren't better, when things are still horrible in 1932, pretty much whoever opposes him is going to be in good shape, the Democratic Party turns to the governor of New York, Franklin Delano Roosevelt, or FDR. And it's interesting to take a minute to talk about his campaign rhetoric. He is not being terribly specific about what he's going to do in response to the crisis, but there is a kind of a new rhetoric in his pitch, as it were. Right, so I want to just pull out some quotes. Right, he said, "We needed and we were ready for bold, persistent experimentation." He talked about a new deal for the American people, and the imagery of a deal, of a contract, but also reshuffling the deck and dealing the cards again, restarting the game. He said we needed to, and I think this is the most important line, recognize the new terms of the old social contract. Recognize the new terms of the old social contract. And this idea is in fact what he did. What the New Deal did really was offer a profound reinterpretation of American liberalism. Not an overthrowing of it, not a revolution, not a radical departure from it, just a reinterpretation of the liberal tradition. And by that, one could say, well, the same values are important. The Constitution is about the protection of liberty. Equal justice under law is important. Personal security and welfare are important values. And what needed to change was our understanding of the role of the national government to secure those old values. Was the New Deal conservative or radical? Well, FDR wouldn't say. He was both. Certainly business interests didn't like what he was doing for a time, but after it was done, they kind of adjusted to it and even liked it in a way. But in any event, much more would be required from the national government to meet threats to welfare that now came from the market and the way the economy operated. In the election of 1932, FDR won by a landslide. He wins by 7 million votes. And the Democratic Party also comes out of that election with comfortable majorities in both houses. So, moving on to slide 2 on your PowerPoint, we're going to start to talk about the New Deal. Historians typically break up the New Deal into phases. First New Deal, the emergency measures of 1933. The second New Deal, the more permanent and enduring and somewhat different measures of 1935. Some add a third New Deal that has to do with the court packing plan and FDR's efforts to reorganize the administrative state and attack his enemies within the Democratic Party. We're not going to deal with the so-called third New Deal, but we are going to talk about the first and second. So FDR comes into office, and the first thing he does is he convenes Congress in a special emergency session. Congress is going to sit for 100 days. And we've heard people refer to what they're going to do in the first 100 days since then. That's a reference to this historic emergency session of Congress. And there's a lot of stuff that's done. There's a lot of emergency measures. There's an Emergency Relief Act that just puts money into the hands of the states so they can alleviate some of the misery. Other things start to develop, regulation of Wall Street. But the two things that we care about here in this con law class, this big survey class, there are two very important emergency measures. One is the and again, I'm still on slide 2 on your PowerPoint. One is the National Industrial Recovery Act of 1933, or the NIRA, National Industrial Recovery Act, which sets up an administrative agency, a new administrative agency, the National Recovery Administration, the NRA. And what does this law do? Well, in this law, Congress delegates vast power to the executive branch. Right, so this new agency, the NRA, is going to sit down with whole sectors of the economy and the leaders and owners of these businesses, representatives of labor, representatives of consumers, and we're going to come up with codes for entire industries. And those codes are going to regulate prices, wages, hours, working conditions, There is a provision that's a precursor to the Labor Act that gives unions collective representation. And it was voluntary to sign on, but once you signed on and agreed to conform to these codes, say for prices, then you had to do that. There was criminal liability if you didn't. And there was a big national campaign to support this. There was a symbol of the Blue Eagle. You would display the Blue Eagle in your window if you were on board. FDR appointed a former military guy, a general, to head it up. And this is an idea about stabilizing the economy. But if you think about government sort of having its hand in the regulation of all this stuff, it does sound kind of like socialism, right? So it's certainly unprecedented. Clearly blurs the boundary between government and the economy. It has the national government doing something it's never done before, and the question, of course, is this constitutional? Is it allowed? Does an emergency change what the Constitution means? The second important emergency measure was known as the Agricultural Adjustment Act of 1933. This is basically price supports for farmers. It pays farmers not to grow things. The effort is to limit supply, thereby raise price and stabilize the markets. Markets aren't working very well. Now, just moving along on the outline. I'm going to add a couple points. This is not on the PowerPoint, but FDR's rhetoric for the first couple of years is scholars call it collectivist. He is pitching this program as we're all in this together. We all have to pull together. We all have a common stake in fixing the economic crisis. But that becomes increasingly difficult. There's polarization. Business interests are getting uneasy about all of this government intervention and what it might mean for them. There are challenges to FDR's left. The Communist Party is getting stronger. Unemployed workers' councils are engaging in actions. Socialism is a viable tendency. So it becomes harder and harder for him to hold a middle ground, right? So there's increasing polarization. 1934 sees two general strikes. Over the summer of 34 in Minneapolis and San Francisco, we have general strikes, and general strike is a pretty serious thing, right? It sort of signals perhaps regime crisis. And we should note that this is a regime crisis. You know, democracies are falling in Europe. Constitutional democracy is not surviving this in other places. So this is a very difficult situation. In the off-year election of 1934, something unusual happens, right? The president's party gains ground. Usually in the off-year election, the incumbent's party loses ground. This is what happened to Obama in 2010. That's how we know it wasn't a huge realignment, although the current party system seems to be breaking up as we speak. But in 1934, the New Deal supporters win seats in both houses. So what were decent majorities are now even stronger majorities in favor of FDR and his program in the House and the Senate. The following year is where we come to the crisis point in the battle between FDR and the court. The New Deal measures are working their way through the courts. They're being challenged. And in 1935, we get decisions, in 35 and 36, both years, we get decisions where the court stands against these departures, where it says these New Deal measures are not allowed by the Constitution. So the next slide, slide 3, gives us the lineup for the Supreme Court for these years, from 1931 to 1937. And the lineup is basically 4 conservatives who are dead set against the New Deal and will always vote against it, unless we're talking about foreign affairs. 2 are kind of in the middle, but they lean conservative. Both of the justices in the middle, Hughes and Roberts, were appointed by Hoover. They're the most recent additions, with the exception of one liberal, Cardozo. There are 3 liberals on your slide, Brandeis, Stone, and Cardozo, who are much more sympathetic to the New Deal, although they don't always vote with it. 6 of them are over 70, and that becomes significant when we talk about the court packing plan. So that's the situation. So the first case, the first New Deal case we read in this class in the Commerce Clause line of cases is the Schechter poultry case. It's also known as the sick chicken case. Right. This is a challenge to the National Industrial Recovery Act of 1933, that it's unconstitutional. The facts don't matter that much, but it's worth sort of relating them. We have a code, and this is how detailed these regulations got, right? We have a code of fair competition for the live poultry industry of metropolitan New York. And the Schechter brothers are wholesale poultry dealers in Brooklyn. So if you're thinking about older ways of understanding commerce, this is the end of the line of the interstate commercial activity. This stuff is going to be it lands in Brooklyn, and then it's sold to retailers who sell it to the consumers. And they're charged with violating the code's minimum wage and maximum hour provisions, its price provisions, and its trade practices or quality standards provisions. Right? They sold unfit chickens, sick chicken case. And there are two intertwined issues in the case. One is, does the NIRA, as applied here, violate the separation of powers because it gives too much lawmaking authority to the executive branch? All 9 justices say yes, it is an unconstitutional delegation of lawmaking power. You can't get that out of the book. It's not in the. You don't get that issue or the discussion of that issue in the book. The second and more fundamental issue is, does the NIRA, as applied to the Schechter brothers, or in general, exceed Congress's power to regulate interstate commerce, because what it regulates is neither interstate commerce nor closely enough or directly enough connected to it? And the court's answer to that question is also yes, it exceeds Congress's power under the Constitution. So this decision comes down in May 1935, and again it's 9-0, and it went against the government on both issues. Writing for the court, in the excerpt we do have in the Bretschneider text, Chief Justice Hughes argues that any connection between wages and hours and interstate commerce is remote. Right? We have a long causal chain, therefore he says this argument really proves too much. Right? We see this refrain again and again. If Congress can reach this on the theory that it's connected to interstate commerce, then it can reach anything on that theory. And finally, there's language in there where this is an aspiration, a wish, a desire. It's ever present. The Constitution doesn't change because of a political crisis. The Constitution is law, and it means what it means, and if it's going to be changed, the people have to change it. This is tough, there's a crisis, there's a need, but that doesn't change constitutional meaning. The Constitution is fixed, it's stable. We want that to be true. So just before it was set to expire anyway, and I didn't mention that it had a sort of had a sunset idea built into it, it's struck down. Now, it's important to note that the New Dealers, FDR and his advisors, are really not heartbroken about the NIRA. They don't mind losing it so much because it wasn't really working that well anyway, and they are playing with some new ideas and new approaches. Right? It's just not. It's too cumbersome and mechanical to really work. What does trouble them, though, is the constitutional theory that strikes it down. That theory of what the Constitution has always meant about limiting the power of the national government, that's going to be a problem for them. What it prevents the national government from doing. Right after Schechter, right, FDR makes a public statement, and he says, I'm quoting, "Does this decision mean that the U.S. government has no control over any national economic problem?" Is that what the court is saying in this context? In 1935, also, moving down to slide 6, there are a number of new laws, and this is what the New Dealers are concerned about. They're legislating. There are three pieces of legislation in 1935 that they care a lot about. One is a mini sort of NIRA for a particularly vital and contentious industry, the coal industry, right? So they passed the same law for a specific industry. It's called the Bituminous Coal Conservation Act of 1935. It included maximum hours, minimum wages in the coal mines, and price fixing, setting prices. And if a producer declines to participate in it, they're going to pay a fairly heavy tax or fine for their failure to participate, right? And this is going to be struck down in another case that we read in the book. It's called Carter v. Carter Coal. I'll get to it in a minute. And then there are also the twin pillars of the American welfare state, right? And these stay with us, but they're under a constitutional cloud. One is the National Labor Relations Act of 1935, otherwise known as the Wagner Act, after its sponsor, Senator Robert Wagner of New York. And this gives unions the right to bargain collectively, and it regulates management labor relationships in a new way. And it sets up a new agency, the NLRB, the National Labor Relations Board, which is rulemaking agency that engages in adjudication. It does everything. It does lawmaking, it does administration, and it does adjudication with respect to labor management relations. There's a right to strike. And that is a questionable law under the doctrines that the court has been embracing. Also in 1935, we have the passage of the Social Security Act, and that's an omnibus bill. Most of us associate Social Security with compulsory old age insurance. You have to pay the taxes, and you get a pension when you retire, or you hope you will. You will if the government's willing to tax. It's not like your taxes go into your account. They don't. But FDR wanted the payroll tax in there so people would regard it as an entitlement. It's almost constitutional, meaning you can't mess with it. Anytime somebody tries to reform Social Security in a significant way, they get slapped down. And FDR said, I put those payroll taxes in there so no goddamn politician, as if he wasn't one, is ever going to mess with this program, and that's basically what happened. Well, in 1936, in Carter v. Carter Coal, the court strikes down the mini NIRA for the coal industry. And the theory there is that coal mining is not interstate commerce. It has only an indirect relationship to interstate commerce. And here the liberals are dissenting. They're saying, look, we have to be pragmatic. We can't be rigid, mechanical, logical about this. It's not a matter of categories. Is it manufacturing or commerce? Is it direct or indirect? We're satisfied that stabilization of this industry is vital to the national economy, but the Coal Act is struck down. Also in 1936, before the election, and this is not a case in the book because it's not about the Commerce Clause, but the court strikes down the Agricultural Adjustment Act of 1933 in a case called Butler. Again, Congress is reaching down to regulate agriculture. It doesn't have the power to do that. What's at stake is the spending power, not the commerce power. So, given these decisions in Schechter, in Carter, and Carter Coal, by the way, it's Carter v. Carter Coal because it's Carter's company and he sues his own company to have the law struck down. In Butler, it does seem like the new laws are in trouble. The Social Security Act and the National Labor Relations Act, both of 1935, are challenged, and if you're reading what the court is saying, they're likely to be struck down as well. But we have an election coming up, right? So now I'm on slide number 8, and in the election of 1936, FDR doesn't say anything about a plan for the court or what he's going to do about the court. The issues are starkly framed. The Republican Party nominates a guy from Kansas named Alf Landon, and the rhetoric of the campaign is really polarized and ideological, right? The charge against the New Deal from the newly mobilized and organized business community is this is socialism. He's taking us down the road to Moscow. You should reject this. And FDR wins by an even bigger landslide, this time by about 12 million votes. And the New Dealers, the Democrats, pick up even more seats in the House and Senate. So we want to pause to think about the Madisonian system at work here, right? It's not one election, it's three. It's 32, 34, and 36. Each time when the people speak, they reaffirm the direction and give it a boost. And it's only after that third election where FDR gets this clear mandate for the New Deal program that he turns his attention to the court, and it's highly controversial. So shortly after the election, in February 1937, he proposes the court packing plan. A little summary of it is on slide number 8. And when he announces it, he kind of tries to couch it in terms of they're old and they need some help with their work. That argument doesn't fly very well, but the proposal is, which he has introduced in the Senate to begin with, is for every judge or justice in the federal judiciary who reaches the age of 70 and doesn't retire within 6 months of their 70th birthday, I, FDR, get to nominate another one. And for the Supreme Court, that would mean that the number of justices, if this bill passed, could go to 15, could go from 9 to 15. Article 3 of the Constitution doesn't say anything about how many justices there are or should be. That's for Congress, unless we amend the Constitution to fix what is arguably a defect. It could go to 15. And when in class we had some debate about, if you were in Congress, would you be a supporter of this? Or if you were a citizen at the time, would you support the court packing plan? And why or why not? And that was a very interesting discussion. It does arguably itself challenge, you don't find these words in the text, but it's clearly a structural principle of the Constitution. It's called separation of powers. I don't like what a branch is doing, and I have the raw power to basically destroy it and establish this precedent that if you get too far out of line with me, I can knock you out of the way in this way through court packing. On the other hand, it is a crisis. The amendment process is unbelievably cumbersome. If FDR proposes an amendment, he's basically admitting that the court's interpretation of the existing Constitution is correct, and that's not what he's been saying. He's been saying they're legislating their preferences. They're importing an economic theory, an idea about political economy that's not in the Constitution. In fact, they're betraying the Constitution. We're saving the existing Constitution, which is perfect and adequate, from these 9 old men or 4 or 5 old men who are just pursuing their ideological preferences anti-democratically. So there's no amendment process that's going to be pursued. I don't know. If it passed, who would say whether it's constitutional or not? What would that look like? And again, when you get to these issues, when you hypothesize the Congress and the President in a deadlock over whether we're going to war and the President says he's going to war, you could say the courts can resolve that issue. They could speak to it. But really it comes down to popular support at some point. And here the popular support is all on the side of the President, at least until he proposes the court packing plan. And then it's more mixed. I mean, even some New Dealers were highly ambivalent about it. We don't... All right, hold on just a sec. I'm gonna stop here. So there's gonna be like an extra, I'll just come back to this point in the second video. I have to go pick my daughter up from school. So we're at 29 minutes. Again, this always takes a lot longer than I anticipate it will. But so this is the end of video number 1, and I'll see you in a half hour.